What happens if a will is unsigned? Hi, I'm estate planning attorney Aaron Miller in Plano, Texas, and today we're going to talk about the requirements of a valid will in Texas. To be a valid will in Texas, you have to have four things. Number one, the testator has to have legal capacity. The testator is the person who's creating the will. The testator has to have testamentary capacity. They also have to have testamentary intent, and they have to follow certain formalities. Legal capacity means the testator has to be over the age of 18, or they have to be lawfully married, or they have to be a member of the U.S. Armed Forces. Testamentary capacity means you are of sound mind. You understand what you're doing. You know that you are engaging in the process of making a will. You know who your heirs and your beneficiaries are. You know what your stuff is. You know what assets that you have. And you know that you're creating an orderly plan for making sure that your assets are distributed the way you want to. Testamentary intent means purposeful will creation. In other words, you're engaging in the process of creating a document that specifically distributes your assets after you pass away. And finally, the testator has to engage in proper formalities. There's a couple different ways you can create a will. You could do it entirely in your own handwriting in Texas. That's not recommended because, while it may be better than nothing, it's going to make it a lot more complicated to probate down the road. The other way you can do it is you could have it in writing, and if you do that, you have to have it signed, and it has to be in front of two witnesses. And there's certain requirements on who can be a witness. For example, they have to be over the age of 14 in Texas, and they cannot also be a beneficiary under your will. Now, that's all that's specifically required to be a valid will in Texas. Although a well-drafted will have something called a self-proving affidavit. And that's a separate document that's attached to the will. It's usually done at the same time that the will is created. That's signed by both the testator, again, that's the person creating the will, and the witnesses. And it's also notarized. Now, several years ago, the Texas legislature allowed us to start merging the signature requirement for what's a valid will and also for the self-proving affidavit. So you may see wills that are perfectly valid that have a self-proving affidavit that just has one signature of the witnesses and one signature of the testator, but that will also be notarized as well. What that self-proving affidavit does is just eliminates the need for the witnesses to come and testify in court later on down the road after the testator has passed away. Listen, if you live in Texas and you're not sure if a will or maybe a trust is right for you, give us a call today.